Ladies and gentlemen, welcome. This is Dan Block with Permanent Solutions Labor Consultants. We appreciate your cooperation to attend today's session once again. Today's topic, historic changes to federal labor law and NLRB update. We do appreciate everybody's attendance today, and we certainly hope that you find the information from our webcast this afternoon to be beneficial in many ways. First off, we certainly are honored to have with us for the first time Mr. Clifford Hammond, an attorney with Nemeth Burwell. If I'm saying that correct there, Cliff, welcome.
Thank you. It's Nemeth Burwell.
Nemeth Burwell. Thank you. I appreciate that. And we also have with us, once again, Ricardo Torres, President, CEO of Permanent Solutions. Rick, how are you doing this afternoon?
Doing great, Dan. How are you doing? And I'm very happy to have Clifford with us also today.
Perfect. Well, I tell you, saying that, Rick, it certainly is an honor to have Cliff with us, especially concerning the topic at hand with these historic changes that we have seen for the first time in nearly a generation, this type of change to our federal landscape as far as labor law is concerned. So saying that, Rick and Cliff, why don't we go ahead and get right to it, okay?
Okay. Sounds good, Dan.
All right. First off, let's give an introduction, a real brief introduction to the two firms that have joined us today. Permanent Solutions, the global leader in labor relations and human resource consulting, specializing in union avoidance and positive employee relations training. The motto for the firm, enhancing corporate DNA toward positive employee relations. Rick, why don't you just add to that just briefly the introduction as far as how long the firm's been in existence and perhaps your mindset when you actually were the brain behind the founding of the firm.
We've been in businesses since 2001, Dan. And I think the model behind our business is to try to prevent issues from happening before they become an emergency. To try to stop union activity before the union's knocking on your door with positive employee relations.
And obviously you have some firsthand knowledge, don't you, as far as the impact of unionization and how that ultimately could be a deterrent on business, its employees, and stakeholders. Would you like to go ahead and add a brief description as far as some of your background specific to that?
Yeah, Dan, I was a high-level union official for over 20 years, and I was a organizing director across the country, national organizing director, and I have over 1,000 organizing campaigns under my belt when I was working for big labor.
Very good. And also joining with us today, as we mentioned, Cliff with the law firm. Cliff, I believe you're actually officed in the Detroit area. Is that correct?
That's correct, Dan.
And why don't you go ahead and give us a brief explanation of your firm, please?
Sure. Nemeth Burwell has been around for 20 years. We're an exclusive management side law firm. We help employers not only litigate cases when they have a problem, but we help to put together, just like Rick was saying before, one of the critical components of any strategy for a business would be to put together preventative maintenance. In other words, we help you with your handbooks, your work rules. We help you think through problems before they become a problem, work with employees, work with your managers, become stronger, and to have a legal defense before there's a problem. And we've helped employers in all areas, including labor law and employment law, and we help litigate against claims of discrimination as well as claims by unions, if you have an active union, or if you have issues that come forth with potential petitions and things of that nature from unions as well.
And Cliff, correct me if I'm wrong, but if I understand correctly, before joining the current firm, you too actually had some experience in working with the side of organized labor. Would you like to add to that, please?
Yes, actually before coming to Nemeth Burwell, I was an attorney with the Service Employees International Union. I worked there for several years, worked before the NLRB with litigation, arbitration, negotiations, and then I came on over to management side and have parlayed my experience and things that I've learned over there into this side to help employers.
Awesome. Well, sir, once again, welcome. And now that we have the introductions behind us, let's go ahead and get things started. In today's presentation, folks, we actually will be explaining a brief understanding of the NLRB change that has occurred here recently. We will offer what its impact will be to the employers and its employees. After that, we will offer the union's perspective as far as defining what this change will mean to us. And we certainly will ask counsel for his opinion as well. Last, we will also offer some advice to employers moving forward and ultimately making unions unnecessary in your workplace to offer you the best security and a financial insulation from the potential problems that occur in the financial consequences to unionization. So let's first talk about the change, gentlemen, that has taken place. In order for many of our audience today to really understand what's happened here at the end of April, the beginning of May, just within the last couple weeks, I believe the best thing to do would be to explain what the rule or the law was prior to this change so that they can understand its impact. And leading up to April 30th, as the law stipulated for a matter of 50-plus years, the process in which a petition was considered, a petition filed with the NLRB requesting an election for consideration of certification to join the union or decertification to kick the union out, that process evolved through this type of time frame. Day one, the petition would be filed with the NLRB, and the company and the union were notified as receipt of the petition from the NLRB agent. Somewhere in day 10 to 14, the National Labor Relations Board would conduct a hearing, and they would monitor that hearing with also parties and representatives from the company and the union to discuss two elements: the appropriateness of the unit and when the questions concerning when the election will be held and in what manner. Sometime within 7 days after that, briefs would be filed by the parties involved and would be considered by the NLRB agent, and a decision, a formal decision, would be made finalizing how the conduct of the election would be held and who is actually in the group in consideration. And from that point, there was a 25-day waiting period until the NLRB would hold the election on site. So if you do the math there, prior up until this point with this change, the time frame from day of petition to when the election would actually be held would be somewhere between 42 and 46 days. So speaking as far as how that was held previously, now let's go ahead and explain to you what the current impact would be on this change that happened as of May 1st. Now, of course, we would have the petition filed on day one. The company and union would be notified as previously. There are no NLRB hearings anymore, no briefs to be filed or considered, and the 25-day waiting period is now gone away. So in essence, by determination of the regional director's authority from the NLRB, the election actually will be held within perhaps as minimal as 5 days, but more than likely somewhere between 10 and 15 days of the petition filed. And clearly, Rick, let's start with you. This could have a serious impact to the employer involved who is caught off guard. As we know, in most of these cases, the employer somewhat throws their hands in the air as if they had no predetermining factors leading up to that petition being filed, and where before they may have had a month and a half or basically 45 days to campaign their message and educate their employees, now they may be left with 5–10 days. Would you mind adding to that how you would explain what the impact of that change would be to the employer?
Well, Dan, the biggest cause of union organizing is a breakdown in communications. A union could be in a facility talking to workers for 2 months, 3 months, 4 months. Even I've known unions in organizing campaigns who have been working with employees for over a year, and in that period of time, they're miseducating the workers. They're misrepresenting the abilities that the unions can bring to the table. They're misrepresenting the power or strength of the negotiating abilities that they have during contract negotiations. And their job is to pitch the management and the employees against each other to cause as much havoc as possible within the facility. So given the 42 to 46 day period of time that you have prior to an election when a petition is filed, previously, at least management had some ability to communicate with the workers to try to re-educate them on what the truths are. In a 10 to 15 day election cycle, that's going to be almost impossible. It's going to be very hard for the for management to re-bridge the gap of communications between the workforce and their frontline supervisors.
I appreciate that, Rick. Cliff, let's ask you, though, in the perspective of legal counsel, obviously a lot of employers who even today may be somewhat in the dark as far as this change is concerned, and literally they have no conceptual idea as far as how this will impact them moving forward, and certainly to the detriment. Some employers actually may be to the feeling of, how did this even happen? But what I'd like to ask you, though, Cliff, in a legal perspective, how would you now approach your client, the company who may be involved with a petition, and trying to offer an explanation as far as get prepared and how they need to handle that campaign moving forward in the short time frame?
Well, it's dramatically different now. When you looked at the old way to do business, when you had a petition filed, the median time frame for an election from the time that you file a petition until the time you have the election for the last 10 years has been approximately 38 days. So like Rick said, you had some time. 90% of your elections are within 56 days after the petition is filed. Generally what an employer would do, you get a petition, you immediately say, okay, we want to go to hearing. You issue a number of questions. You bring witnesses to talk about who should be in the bargaining unit, who should be out, and you litigate whether people were supervisors, whether they are properly before the board or not. Under the new rules now, you're looking at a potential, though, of that being gone. Now, there are exceptions under the new rules, even though you can still challenge the appropriateness of the union, of the unit of employees that are going to be represented. However, there's deference given to the union's concept of what they think the appropriate unit is, and unless there's a very small special circumstance, you're not going to be able to even challenge whether or not a person is or is not a supervisor. So you have two choices. You had the old way of doing it, which was the board set a 42-day time limit, but if you went to a hearing and there were questions, you could go ahead, litigate those issues, and then before an election, you can ask for an appeal to the National Labor Relations Board, and that, again, would cause more time, and you would have an opportunity during that time to not only litigate, but also educate your employees. Now, what these rules do is if you go into that litigation mode, they would limit the period of time that you have, because if you choose to go down this road and don't stipulate to an election period, you will have an opportunity to have a really quick election. So it kind of flips the onus now. Under the old rules, most employers would not stipulate to an election because you have issues you want to litigate, and it takes time, and you want to make sure all the issues are ferreted out properly. Now, you wouldn't necessarily want to stipulate because you don't want to give away your rights to talk about who's in the unit, who should be in the unit. But now under the rules, you might be able to go to a 42-day limit if you stipulate with the union. However, there isn't necessarily a lot of pressure on a union to stipulate. If they can go forward with a non-stipulated, go to the normal process, have the regional director go ahead and direct an election, and have all your objections afterwards. And under the special circumstances, if you have legitimate reasons, whether or not the employer is large enough to actually be under the jurisdiction of the NLRB, if there's a bona fide question about the appropriate unit, or if there is an issue of whether there's sufficient evidence showing of interest, in other words, whether the union has enough cards. If one of these issues is up, I mean, potentially you could have a hearing. But most likely you're not going to. So you're fighting now to determine whether you should stipulate or we should just go to an election and have those issues deferred because the regional director or the hearing officer can actually just say, let's wait until after the hearing's over to figure out whether people are supervisors or not. So you have a very quick decision to make about whether you want to agree to what the union has said or whether you want to wait until after the election is over and have a really quick election without the opportunity to really educate your employees. So it's a difficult and very different situation to be placed in.
Well, Cliff, I'd like to follow up with that because in some of the published comments from the National Labor Relations Board leading into this decision that they have voted on and made, they justified this change with the statement of the unnecessary financial expense to all parties involved in this litigation process of this, not necessarily appeals, but the determination of these questions prior to the election being held, which elongated that process, when certainly to the advantage of the employer to continue that education. But do you really feel, as a legal counsel, do you feel that there was some fact in their justification of the legal impact? Excuse me, the financial impact?
Sure. I don't believe that the financial impact really ferrets out. I mean, if you take a look at the timing of the elections from the time the petition is filed until the time you have an election, there is just not that much time. I mean, the numbers are what they are. You have, only a median time of 38 days. That's a very short time for an employer to put the campaign together. You have legitimate issues that have to be raised about, under the law, who should and should not be in the union. I mean, there are laws in the National Labor Relations Act that say that supervisors cannot be in a union. And if you don't litigate that issue, then you can't operate your structure properly after you have the unionization take place. So if employees want to have a union and then supervisors are in part of that union when they vote and then are taken out later, it causes chaos. So the economic impact of the litigation before you have a vote is well worth it. It's appropriate, it's necessary, and it's been shown and borne out to be timely and more inexpensive than having to figure it out after the fact. So if you have an election, you have people in there, and then later on you find out through litigation, which is going to cost money after the fact anyway, that they shouldn't have been there in the first place, and it might have had a bearing on the election because you had a very close election, then what do? You have to go back and spend more time, more money to have another election. It would seem more practical and economic to just simply have the issue disputed first in the beginning, get a decision, and then go ahead and have an election. So I don't think there's a lot of merit to that issue.
Rick, I'd like to bounce back to you, please, if you don't mind. Let's talk about that time leading up to the petition, because I think it's important for employers to understand. And as you and I both know, Rick, from our experience, and I'm sure Cliff would agree to this too, it literally is amazing how often we hear of an employer who has that sense of shock and awe, like they literally felt like they had no idea that there was any underlying campaigning going on. They were completely caught off guard with the idea of a petition being filed. How could this happen to us? We thought this would never happen. But, Rick, my question for you is, can you offer some kind of explanation as to how long the union campaigns leading up to that case in order to establish their position, if you don't mind?
Well, yeah, Dan. In fact, there's no given time frame. I mean, like I said before, it can last for over a year, or it can be as quick as a month or even a couple of weeks, depending on the issues that are happening inside the facility or how frustrated the workers are. But once again, Dan, it's the union's job. One-on-one union organizing is to keep things quiet from management, so they don't have the ability to start educating and clarifying issues to their workforce. It's their job to shock and to surprise management. The perfect organizing campaign starts or ends the secret portion of it, or the underground portion of it, is with the petition. And the perfect campaign is if an employer gets the petition and it's the first time that they know about any organizing activity within inside the facility. So you know, I mean, the job is a shock and all, and with a short, election cycle, if it's within 15 days, the union's not going to have any problem keeping chaos happening within inside the facility to keep management on their heels and surprised, and not give them the ability to educate and to do the due diligence with their workforce.
And Cliff, once again, coming back to you, you know, even the U.S. Chamber of Commerce in their comment pertaining to this decision by the National Labor Relations Board, calling it the union ambush, eliminating employers' due process rights. Is there, where do we stand, Cliff, as far as potentially this decision that was made by the board being reversed or countered somehow by some type of federal judge's decision or otherwise?
Well, there's always an opportunity it could be overturned, but right now you have a rule. It's in force and it's in place. Just before the rule being implemented on April the 30th, the U.S. Chamber of Commerce asked for a stay and an injunction, and the judge refused to give that. So there's ongoing litigation. There's no timetable, and it could happen at any time. Win, lose, or draw, the decision will come out. But until then, employers are subject to this rule. So you have to operate, if you're a prudent employer, understanding that this is the law that you're under. And if there's a change in the law coming forward, that's great news for us if this is struck down as a due process issue. But ultimately, judges make those decisions, and it's going to continue to go through the process for quite some time. The NLRB, if they do lose, will probably appeal. Same thing for the U.S. Chamber of Commerce. I would assume they would do the same thing. But at this point in time, this is the law, and these are the rules, and there's nothing saying it's going to change any time soon unless we get an injunction out of the blue, but we don't know when that'll be.
Right, and I appreciate that, Cliff. To both of you, I find it something of interesting, since this actually has occurred now in the last couple of weeks, we as practitioners of labor relations have somewhat been interested to see what the impact would be from formal organizing drives being conducted throughout the country. I could tell you as of today, now that we are literally a week into this change, we have already seen about a 50% increase to the quantitative number of petitions that are being filed in the country. And what's interesting is a side note to that, for instance, today we actually saw 3 petitions filed for the same employer at the same location, in essence seeing some of the results of the reversal of the specialty healthcare decision, where now the unions have the right to file these petitions based on micro-unionization or select groups by community of interest. So, Rick, let me first address that to you. You know, leading up to this point, as it has been for a number of years, unions have been successful in winning the election under the previous rule of law to the extent of around 67%. Now that we have the expedited elections in place as current law, as Cliff was saying, what do you feel will be the success rate of the unions winning these campaigns moving forward now?
Well, Dan, and it's a lot of unknowns. And I will say this, is that years ago when I started working with the steelworkers, when I came over from the International Brotherhood of Teamsters, I was instrumental in putting together a merge with the Canadian retail workers in throughout Canada. And for the first few years, when we had the short election cycle, and it was between 5 and 10 days, our win rate was, and this is a law that existed in Canada prior to us merging with the retail workers, but our win rate for the first couple of years that I was actually on the ground working with the organizing teams, what shot up to about 90%. So I predict that the win rate is gonna shoot up tremendously, and like I said earlier, having a short election cycle is going to give the unions the ability financially to attack the companies very aggressively and keep that momentum going for that short period of time. But I expect it to kick up, and I wouldn't be surprised if it went close to the 90% range also.
Thank you, Rick. Cliff, let me follow up with you, though. Talking again about this micro-unionization rule, the reversal from specialty health care now, where we now have select groups by that community of interest test could be unionized and separated out under a separate petition, permitting union smaller groups, encouraging incremental organizing, as we say. Employers are confronted with an increase of union petitions as a result of that, and the example today, I think, is clear of that. 3 petitions, 3 different groups under the same roof. Moving forward, though, Cliff, how do you see that would be a problem for an employer now that the unions could perhaps select smaller groups and infiltrate an employer through the organizing of select groups?
Well, it's a very effective tool. From an employer standpoint, it's almost a perfect storm. You've got micro units. In other words, an employer potentially could be sitting there with a group of employees that look a lot alike and are treated a lot alike, but somehow a union goes in there, finds a reason why there's a difference and gets only a handful of them, or maybe a couple dozen employees. They go out, they get some cards, they're disgruntled because of 1 or 2 emotional issues. They come to the board under the new election rules. There's deference to that unit, plus you've got the micro-unit decision, and you've got this shortened time period. So all of a sudden now you've got an election on a small unit you never even conceived of being its own unit of organized people, and you're stuck with the union. Now you've got full-time union on your hands, and they're going to start talking to other people. So it's kind of a situation where an employer has to deal with not only the legalities of what is a unit, but then the shortened time frame to be able to talk to them about their particular issues and not a bigger group about the overarching benefits of the entire organization. So it does hamstring the employer to a certain extent, but on the other hand, it is a benefit for an organizing campaign, and the limits that are being placed on you by the election rules are real. And so that's why, to a certain extent, you need to take some preventative measures to understand what's going on in your workplace because of this.
Hey, Dan, I'd like to add something to that. Dan, I'd like to add something to that also. It's also going to open the door to make it easier for unions to come together. So rather than have one union go after a community of interest within a facility, you might have 3 or 4 unions who actually work together to go after a company to be able to utilize the resources from different unions to go in there and cherry pick who they want the members to be. So it's going to make it a lot easier for unions to collaborate on organizing campaigns.
Well, if you don't mind, add to that a little bit, because I don't want the audience to be a little confused there, Rick. Let's take an example, for instance, of a hospital, and I realize they fall under the definitions of community interest that was originally defined by specialty health care, but nonetheless, you have all these different groups. You have nurses, dietary, maintenance, office and clerical. Explain to us again how the unions, in a cooperative manner, would work together instead of rating each other for the greater good of organizing that facility and all?
Well, to some extent, that's happened in the past. When I was with the Steelworkers, I also put together a merger or organizing agreement with the California Nurses Association, and we went after different units of the hospital. They would go after the nurses, and our part of the deal would be that we would go after everybody else, and we would work in conjunction with each other. But what's going to happen now, and when I was a organizing director, one of my goals was to build coalitions of unions together to go ahead and work at facilities to try to bring in all the resources, or go after an industry to try to utilize all the resources from different unions within the AFL-CIO. So it would be a lot easier for us. We'd have a lot more strength going in instead of fighting against each other. But now it's gonna make it a lot easier, because you have the micro units, you have the smaller units, you have the, as Cliff said, the faster timelines as far as the elections, it's going to make it a lot easier for unions to say, okay, let's go after an industry or let's go after a region and organize together, and we can share the costs or the expenses of offices or organizers and all the things that go with it, and let's go after and cherry pick this facility or this industry or this region. So it's just going to make it a lot easier for them to come together, to work cohesively together, and bring down even more the cost as far as organizing workers.
And I guess what? No, go ahead, Cliff, please.
Let me just piggyback on that, because I think that Rick makes some excellent points there. You know, organization-wise, you know, for a union, the rules that are being implemented, as well as some of the decisions that are being done in almost a pragmatic, systematic way to allow for newer, better organizing efforts. And you take a look at how big can unions be. You're looking at what are the objections you can use. You're looking at the time frame for the objections. Every single one of these addresses an issue or a point of contention that has been problematic for the growth over the last 15, 20 years. So what you're seeing is a systematic dismantling of hurdles that employers have been able to either, one, expose, or two, show and demonstrate to the board as reasons why tactics of organizers should not be allowed, because now you've got an opportunity for people to run and not have to jump over to things that have been put in place for protections so that employees have the right to be educated before the decision is made. And now you're having this ambush, if you will, election, which is not allowing the appropriate barriers for just a rush to judgment, instead of just saying, wait a minute here, let's listen to what's going on. You know, put the unit appropriate. There are reasons why there are units, you know, historically, that have been whittled down. There are reasons why you've had 25-day limits before the election, so that people can think about things. And there are reasons why there shouldn't be deference to certain types of units. These are all put into place as protections for employees that are now systematically being taken down. And as Rick said, it's not falling on deaf ears. I mean, these are openings, gaping holes now for organizing drives.
Great response there, Cliff. Moving forward, I guess the question now is, now what? One of the things that I think that we were expecting, which is coming true, is seeing an immediate increase in some organizing activity throughout the country. I believe that many employers will, if they have not already, will have a sense of heavier solicitation of their population. More petitions are being filed. We already have addressed that just in the first week, that we have seen about a 50% increase. Organizing intensification, infiltration through smaller units, as both of you have addressed, a corporate attack to corporate campaigns, literally going after the employer through the detriment and smear campaigning versus actually attending to the likes and the emotions of the employees directly, and the obvious increased threat of strikes. Well, management certainly is going to have a harder time enlisting supervisors to assist in the communications. Let's first talk about that as far as the approach and handling a campaign under the expedited election. Rick, let me first go to you. I know that Permanent Solutions, as one of their service offerings, will be engaged with an employer to come in and assist in not only aligning communications through the management so that there's a cohesive and consistent message aligned through management during that shortened time frame of a campaign during a petition, but how do you see the challenge now in enlisting their immediate supervisors to assist in that communication?
Well, and it goes on to what Cliff was saying as far as the confusion of who is a supervisor and who is not a supervisor. I mean, one of our goals when I was a union official and an organizing director was to always try to utilize the relationship between the workers and the frontline supervisors as much as possible. And to be totally honest with you, Dan, it was very easy to turn a lot of supervisors over and get them working for us because you know, we had our tactics as far as turning them, but working on the relationships between the workers and the supervisors was very important. So having the confusion of and the inability to prior to an election to clarify who is a supervisor and who is not a supervisor, and maybe having to wait until after the election is completed to try to unscramble this egg is gonna make supervisors a bigger target, and unions are going to go after supervisors who where there is a question, where normally that they wouldn't because they don't want to get into the long litigation, but would do it now, and then use those supervisors to help them with the organizing campaign. It's just going to tie the hands of management even a little bit tighter behind their back, knowing that unions are going to be targeting those questionable management members even more.
Well, I must admit to you, Rick, and Cliff, this is really a question for you. I was a little caught off guard by one of the recent notices that were published by the NLRB as a matter of addressing their advisement of how these issues will be conducted after the election's held. And certainly that leaves the challenge of many of the questions being unanswered as far as these supervisors. What caught me off guard was they explained if there was a problem, for instance, as both of you are speaking of, maybe someone's a supervisor, are they not? Well, why don't you handle that? The advisement from the NLRB was handle that with the union through negotiations is how you would address it then. Cliff, don't you see that opening up somewhat of Pandora's box to the benefit of unions to be able to use that in their favor then?
Oh, absolutely. I mean, it's almost forcing you to negotiate before you have a duty to bargain. I mean, it's not an appropriate way to handle the matter at all. It gives an upper hand, and tactically, it doesn't make any sense. I mean, pragmatically, you're not going to do that. So it's putting the cart before the horse is what the problem is. And the whole mechanism for deciding who is a supervisor after the election just causes an unanswerable problem. And that's what this answer is. It's not an answer. It's more problems. And the entire scenario of not knowing who your management team is during the midst of an election is just something that you cannot remedy after the fact. Because how do you remedy it? Let's say the employer says, I know that's a supervisor, they shouldn't be in there, and they go ahead and they utilize the manager as you would traditionally in a manager situation. Well, if the person's in the unit and then there's an objection by the union later, what if the board decides they're not a supervisor? And the employer won. What do you do? I mean, there's just so many questions that have to come up because of this that should be answered beforehand. And it's difficult. It's difficult for employers to try. So you have to know what you're doing beforehand, and talking with the union ahead of time just doesn't make any sense.
Well, before we get into the proactive measures, our advisement to employers, what do we do now when we don't have a petition? Rick, I want to go back to you on something that we have talked about, and I know completely from conversation with Cliff how he will support this. We talk about the DNA of a company and how, in essence, once the union is in, how quickly the company's DNA adapts to that change and simply accepts it. Not necessarily accepting it wholeheartedly, but accepts it to the fact that they no longer have that bitter taste in their mouth to want to fight or debate the issue or even try to do anything about it. I know in some of our training we use the example of TSA before and after 9/11, how before 9/11 everyone would go to the airport and you never thought twice about going to the gate to see a loved one when they got on a plane. And now all of a sudden 9/11 happens, and our DNA approach to travel by air had to change drastically. And certainly we all had to adapt to the challenges and the time consequence of dealing with security measures. But now as we travel week in and week out, we have accepted that. We may not necessarily like it, but we accept it as practice. So Rick, getting back to you, would you first address to us your concern as a practitioner of labor relations? Explain your concern of how companies need to be aware of how easy it is for their DNA to change, which leads to the reason why proactive measures are necessary.
Yeah, Dan. You know, in fact, it's like Cliff was saying earlier about you know, will this law be turned over? Will it change? And right now, the law is what it is. It's changed, and this is what it is. And once again, as Cliff was talking, I was thinking that, yeah, once an egg is broke open, how do you change that? It's very, very hard. And you're absolutely right. Once a union gets in, it's very hard to change it because people start to accept the differences and the changes that happen. The corporate DNA, as you said, Dan, starts to change. So the routines start to change, and they start getting into a rut as far as how they deal with the union. So it's very hard to change it, not just from a practical point of view, but from a psychological point of view also. Because once people accept something and they start getting used to the day in and day out grind of dealing with it, once again, it's very hard psychologically to change that attitude. And we have examples of that through history. I mean, you look at some of the changes that have happened through just the 20th century. Social changes that have happened. It's taken years to educate the public on why something is a bad law. And even though it makes complete common sense, people are used to it, and change is hard to come by. And it's the same thing that happens within companies, within the DNA of companies. Even though they know that it's better to change it and to go back to a system that was there before prior to the union being involved or to the union winning an election, it's still very hard to do.
Thank you, Rick. And Cliff, if you don't mind, I want to ask you to offer an opinion on this too, because I know as a retained counsel, you work with employers day in and day out and advising them on these matters. And I'll give you the example leading to my question for you, Cliff. Rick and I have recently worked with a client who was recently involved with a petition election, and the union was voted in. And when you speak to management who were involved in the process, you really could capture the sense of their emotion, to the frustration, the stress that they've had to endure, and identifying with the challenges of that change. And literally, they are accepting the DNA change, but they clearly have a bitter taste in their mouth because they realize what this is, or the impact of how this has changed their company. Unfortunately, if you speak to a manager or even an employee who is brought into the company once the union is established, and you ask them, hey, is this a good thing or bad, to a general sense, the comment is, well, I don't think that there's really anything wrong with it. It's just a matter of how we have to conduct our business now. So clearly, the newer employee, as time goes on, they simply adapt to it and they accept it, although they may not necessarily like it in its entirety, but they learn to accept it. So saying all that, Cliff, how do you advise to a non-union employer that sense of emotion and certainly the sense of concern that they must have in order to insulate their vulnerability of becoming union in a proactive sense?
Well, there's a lot of things that you have to do. You can't just do one. I mean, it's a systematic issue. In order to increase awareness, you have to provide examples. This is what we do. This is what makes us a good company. This is why employees like us. This is what we can't do if this is to happen. And once they understand the rights you have in being union-free versus the rights you have when you are in a union shop, and how they're so much different. So your ability to be a good employer, to work with individuals, to work with people, and as a manager, I mean, managers have to be educated too. Look at the good you can do. Look at the efficiency you can have. Look at the relationships you can build. Look at how we can help workers become better. And look what it's going to take away from you. And that's what I've seen historically, is when you sit down with people and you walk them through on a point-by-point basis what the law says you cannot do when you are organized, they start to become more emotionally engulfed in it. And it is difficult. Once you change and people say, well, it's just the way it is, you know, that's life, and they just accept it as being what it is more difficult. But when you're in a unionized setting, It is a completely different mindset. And so if you don't appreciate what it is as a manager that you can and cannot do, the authority and the effectiveness, then you might have that. You might even have managers from before become apathetic to it. So it is important to teach companies about the rights, and it takes time. And it really does. It takes time. It takes education. But it's an eye-opener, and I think people really do appreciate it once you do that.
And Dan, you know, the thing about it is also is I think the most important thing is consistency with how you treat your employees and how you implement your rules within the facility. And we've talked about this before, Dan, is that to stay union-free, you have to make staying union-free part of your corporate DNA. And that means long-term commitments to how you treat your employees and how you communicate with them. And long-term commitments is what's important, not just when things are running smoothly or when everybody's having a good day, but most importantly, when things aren't running smoothly. Keeping how you treat your employees consistent.
I tell you, I can really appreciate what you're saying, Rick, as we know all too well, and I'm sure Cliff has seen this too. Many companies feel, well, if we get that shot today, then that should take care of us for a couple of years as an inoculation. And literally, it doesn't work as easy as that. We know very well that as appreciative as management may feel even after some strong training, what do they do once they leave the room that the training is held in? You know, how do they take that to their workplace day in and day out 24/7? So let's go ahead, gentlemen, and just briefly talk about a couple points here of the proactive measures. The company needs to gain an appreciation to the investment and their current labor relations practices and what great return they have on the investment in order to insulate their vulnerability to that unwarranted third party. Understanding the financial impact of unionization. And we are referring, folks, to the impact of unionization to its company, to these stakeholders, its employees, to the tune of financial impact relevant to monetary value and the emotional impact that it may have as well. And clearly the financial impact to the customer and knowing that they are working or that they actually have to work through a unionized environment now. Establish positive employee relations practices. Educate your leadership. Make sure they understand their role and responsibility to labor relations. Do they clearly adhere to with 110% commitment to the company's established labor relations position? Make sure they know their rights per the National Labor Relations Act. And form that first response union avoidance team so that the first sign or indicator that you may have of a potential third party wanting to intervene with your company, how do you immediately respond and what steps do you go through? And practice will perfect that operation. Proactive measures continue. Management must know, and Cliff, you actually mentioned some of this, what they can say and do, what they cannot say and do, the goal that you wish to accomplish as a company, and the message that you wish to relay to all those involved. Management must communicate to the employees involved their rights per the National Labor Relations Act. They must communicate the company's positive benefits. Just because you are taking a position on this matter does not mean that you are anti-union. Establish the communication and understanding with your people that you are pro-employee. Make sure that all employees, from management down to the hourly folks, understand the company's position on labor and employee relations. Make sure the employees understand the seriousness of unionization. Offer your facts, opinions, and experiences. And clearly, management must never, all members of management must never threaten, interrogate, promise, spy or surveillance, or discriminate against the employees concerning their union position. The more you ensure these things, the less appealing the unions will be to your people. And let's not forget and remember, employees don't vote for the union. They vote against management. It is typically the better of the two evils. And unionization is all about power. The power of money to the union, which is their only source of revenue, and the power of respect to the employees. And correct me, Rick, but the last time I saw, I have yet to see a collective bargaining agreement that guarantees respect to the employees on behalf of management, correct?
Yeah, there's never, I've negotiated a lot of contracts in my past life, and I've never negotiated anything, Article 5, Section 7, that said my boss can't be a jerk or the employees can't be jerks. It's all about common sense, Dan.
Right, I appreciate that. Remaining union-free, folks. Employees must understand the purpose of saying no to unionization. If that is the company's position to remain and secure their union-free advantage, they must acquire, with certainty, 110% commitment by all members of management. No rogues in the organization. Business as usual. Stick to the facts, maintain professionalism, and support pro-company employees. Not that you want to push back pro-union employees, but clearly you need to be able to win their trust back, those who may stray away, and offer education. Gentlemen, let's lead into final comments now that we have explained some of our advisement. And I will start with you, Cliff. As a seasoned, tenured labor relations counsel on behalf of management, what advice do you offer an employer moving forward, knowing the immediate change that is endured here with this change of expedited elections?
Well, you know, this is akin to what we do a lot of labor work. That's what my predominant thing is, but I also advise, and our firm advises people on employment law. And a lot of employers are familiar with doing non-harassment training and things of that nature. The regulations may change, but the principles have to stay the same, and that is just what you just went through. If you do the things like treat employees the same, you do what you need to do to educate your employees, you're going to be in a better situation. Having said that, if you don't, the rules are what the rules are, and they are very, very simple. The union can come, and they can shove an election as quick as you can ever imagine, and you will have to be faced with the fact of, does your employee, do they trust you? Do they have a connection with their manager? And if you have not trained your managers, if you don't have a change in your corporate DNA, then you're going to have to live by that in a shorter period of time without the opportunity for the appropriate due process, in my opinion, before the election occurs. So live a certain type of managerial style, and you'll probably be better off by it. You won't have the problems of having a unionization in the first place, but if you do, you can face it very simply because you can't change quickly. So I would advise employers, now that the rules are there and you've got to take this quick election, you need to take proactive steps to make sure that you have a corporation that not just one time has some sort of seminar, but you actually on a daily basis are continuing to revisit it and teach and learn.
Very good, Cliff. Rick, let's go to you for final comment. As you and I both preach to employers day in and day out, under unionization, that will allow a company to do things right. In essence, they will be allowed to do things by the book, which is exactly how unions want it to work. But, however, the most critical element in the practice of true, honest employee relations is the flexibility of being able to do the right thing. And that clearly is the piece that is up for gamble if a company is unionized. Go ahead and offer some explanation as far as that's concerned, and in your perspective, some final comments now that this change has occurred, Rick.
Well, I think Cliff pretty much summed it all up as well as can be summed up, and I think to summarize everything that we've talked about as far as staying union free, I think there's three words that I would use on how to stay union free. And it's communicate, communicate, communicate with your employees. Positive communication with your employees is going to stop the issues before they start to happen. The union when they first come in to look at whether a facility is worthwhile organizing or not, when they start to talk to the workers, the first thing that they do is very similar to a state or federal inspector who comes and looks at bridges or foundations or tunnels or underpasses. They look at the strength or the weakness of the foundation of any structure. It's the same thing that a good union organizing team will do also. They look at the strengths and the weaknesses of the foundation of that company. And the strengths and the weaknesses are, or the foundation is, the frontline supervisors. So once again, consistent communication with your people in a positive way, in a respectful way, is the most important thing you can do to stay union free. And as Cliff stated, that the law is the law, and it's changed, and it's making it harder for unions to have time to communicate once there is a petition. The goal is never to wait until you get a petition before you start communicating with your people. Do it now.
What a great end question there. What are you doing right now to secure your advantage and your competitive edge? Rick, thank you so much for joining us, and equally, Cliff, thank you for your first time in joining us with Permanent Solutions in these webcast seminars.
Oh, thank you.
We certainly hope that you would consider Cliff joining us again. I think it's been a great advantage to have you on board to join us, and your insight has been certainly worthwhile, and it's been an honor. So we certainly hope you'll consider joining us again in the near future.
Absolutely, Dan. I appreciate you having me.
Thank you. With that being said, on behalf of Cliff Hammond and Rick Torres, my name is Dan Block. We appreciate all of you guys joining us today. Have a great afternoon, and for all of your labor relations needs, please give us a call. We are in your corner. Thank you.